the motion as of yet, Your Honor.
Okay, well, I'm going to go ahead and take a recess at this point. Let's go off the record. I just want to discuss procedurally where we are with counsel on these late filings, make sure everyone's had an adequate opportunity to review the filings that have all been filed today, including the court. And it is still my intention to go through with these hearings today and hopefully be able to get through everything and bring this matter to a conclusion today. But we do need to allow adequate time for that. So at this point, I'm going to call a recess to the hearing. I would ask that Madam Clerk arrange for a breakout room for the state and both defense attorneys and me. I'll have actually Ms. Gibson, the court reporter, also there in the breakout room. And I just want to discuss the logistics of getting these motions cross-submitted so all parties are aware of what's been late filed in the case. So that we'll take a recess at this time and wait for the breakout room to be available.
Thank you, Your Honor.
Let's see, do we have Mr. Means or is he still on break here for a moment?
Your Honor, I'm here. I'm sorry. Let me start my video.
Okay.
Let's see. Actually, Your Honor, it's saying I'm unable to start the video. I think I'm going to log out and try to re-log back in if that's okay.
That's fine.
Can you hear me, Your Honor?
I can, Mr. Means, can see you as well. Okay, we'll be back on the record then. Cases CR 2220-755 and 2220-838, State versus Chad Daybell and State versus Lori Vallow. We took a recess for the parties to review and receive these additional pleadings that have been filed in the case. I believe the parties have all had an opportunity to now review the pleadings. Mr. Means, did you receive a copy of the state's motion for testimony of Summer Shiftlet?
I did, Your Honor.
And Mr. Pryor, did you receive that as well? You're on mute, Mr. Pryor.
I apologize, Judge. I did receive all of the documents, Your Honor. Thank you.
Okay, thanks. I appreciate you taking a moment for the housekeeping issues. Understanding we've had a lot of things filed here in a compressed time frame. And at this point then, I do want to take that motion up. It was requested to be done on an expedited basis, and as I understand it may have a relation to the hearing we're determining today, so I think it's appropriate to hear that first. I would note that in addition to the motion, there was an affidavit of Mindy Gee and then a supplemental affidavit of Mindy Gee, which I believe counsel has seen as well. There was also an objection to the affidavits filed by Mr. Pryor on behalf of Mr. Daybell, asserting that they contain hearsay. So Mr. Evans, if you'd like to present argument on your motion for testimony of Summer Shiftlet, I'll hear that at this time.
Your Honor, thank you. And it's just argument. Your Honor, as the court, I know the courts probably haven't gotten around to look at our brief, but motions to disqualify are viewed with caution. And when it's not dealing with current or former clients, there's heightened scrutiny that needs to be applied. And I've cited the case for the court on that. Witnesses are the most important aspect of our cases, and that's because they perform the sacred duty of assisting the court to discover what the truth is, and frankly, to assist all of us. This is why before they even speak in court, they need to affirm under oath that they're going to tell the truth. Where we've been the last few days, Your Honor, the defense wants the extreme remedy to remove Mr. Wood from this case. They claim he's been coercive, influence, coach, and this all has to deal with Summer Shiftlet and in his meeting with her on October 1st of 2020.
Your Honor, if I may, I apologize. I think it has to be said that we're arguing the motion for the testimony of Summer Shiftlet. They have cited one rule in their motion, and we are well beyond that one rule. It attempts that they're trying to backdoor in additional arguments for this motion. And having failed to cite this, I don't think that's proper before the court.
I concur with Mr. Means, Your Honor.
Okay, let me address that, counsel. We are obviously still going to have closing arguments on the motions to disqualify the prosecuting attorney. We've got a narrow issue before us on what's styled as a motion for testimony of Summer Shiftlet. And in reviewing the motion, Mr. Evans, I will just read directly from it that you've indicated that the motion is made pursuant to Rule 4.2 of the Idaho Rules of Professional Conduct, and you're requesting that this court contact and hear testimony of Summer Shiftlet. So I'd just like you to confine your arguments to the narrow issue of whether or not this court should contact and hear testimony of Summer Shiftlet, and if so, when would you be requesting that that take place?
Your Honor, very good, thank you. Once Ms. Shiftlet, so the history on that, after our hearing a couple of days ago, everyone knows Ms. Shiftlet called the prosecutor's office.
Judge, I'm going to object at this point. I've filed an objection to Summer Shiftlet's affidavit being considered in this particular case. If Mr. Evans would like to cite the case and the case law and the statute that grants the court authority to hear Ms. Shiftlet, by all means go ahead. But if he's going to regurgitate things that have happened that are clearly inadmissible, we're going to have a problem. And I'm going to strongly oppose this going down this path at this point.
I understand, Mr. Pryor, and I think to correct you, it was the affidavits, not of Summer Shiftlet. She hasn't submitted any affidavits.
Mindy Gee, Judge.
And there was a objection made based on hearsay, and I am going to consider that objection and hear and rule on that before we get into what Ms. Gee has to say in her affidavits or what Ms. Shiftlet is alleged to have said to Ms. Gee. So I would like to hear, Mr. Evans, there's an objection to those affidavits requesting the court not consider them based on hearsay. And what is your response to the hearsay objection?
Your Honor, it doesn't go to the truth of the matter asserted. Also, she just wants to talk to the court. That's the bottom line.
Who does?
Ms. Shiftlet.
Your Honor, I've got to object to the representation of what Mrs. Shiftlet has allegedly said to this Mindy Gee, now attempting to come in through Mr. Evans. I mean, we now have multiple levels of hearsay here. And quite honestly, this motion has been, it was identified 10 to 14 days ago. Forgive me, I don't remember the exact date. Mr. Evans, in his own argument, has had plenty of opportunity to attempt to contact Summer Shiftlet or even opposing or Mr. Garrett Smith. And it doesn't appear that there were any efforts to do that prior to the hearing 2 days ago. And so again, if we're going to make statements regarding what somebody said to somebody, again, additional problems.
All right.
And Judge, if I could just add that even if Mr. Evans wants to suggest he couldn't go to get a hold of Ms. Shiftlet because of Mr. Smith, we have a subpoena process. And I would assume that 2 lawyers from the state would understand that they have every right with 2 weeks notice to subpoena any witnesses that they feel would help their case. Instead, what they did, Judge, is they provided no evidence whatsoever. And at the conclusion are attempting to do this backdoor tactic, the same kind of backdoor tactic that we had one of the other expert witnesses talk about.
All right.
Bringing,
we're beyond the scope of a hearsay objection as well. So I want everybody to keep in the confined scope of a hearsay objection. Mr. Evans, you indicated it's not being offered for the truth asserted, but you are turning around and then saying, well, here's what someone told Mindy Gee. So I just need to know, do you have a specific exception to the hearsay rule which would allow consideration of these affidavits?
Your Honor, thank you. We're just looking at Rule 803. I think under 1, the present sense impression, so a statement describing or explaining an event or condition made immediately after perceived it, and then as well as the catch-all, the other exceptions, looking at the trustworthiness of it, the factual basis of it, and then the probative point of it. So that's under Idaho Rules of Evidence 803.
All right, I'll allow a response to the argument that there's an exception that applies here under 803.1 in the catch-all. Mr. Means first, and then Mr. Pryor, and counsel, please, again, we're only on an issue here of do these affidavits contain hearsay? You'll have plenty of time for other argument on the other bigger issues here, but keep it confined to that. Mr. Means, what's your response to the state's indication that there's an exception that would apply?
Thank you, Your Honor. In looking at these affidavits, there's not a lot of difference between the two of them. I think we do have a problem where we have hearsay and then we have double hearsay. And I think the analysis would have to be provided at both levels. I think the present sense impression does not apply, to be quite frank. And trustworthy, I think we have an issue because I don't even think these could be characterized as midnight affidavits, considering this is after the fact of the hearing. This is more of the morning after. So I think trustworthiness is an issue as the prosecution attempts to be coming kind of in a backdoor manner to address what should have been addressed at the hearing 2 days ago.
All right, thank you, Mr. Means. Your response, Mr. Pryor.
Judge, I'll start with the last one, which would be the catch-all, which is usually a tactic used in court to try to get something in when there's no other reasonable reason to get it in. So that's not applicable in this particular case. Trustworthy is not applicable in this case. That's for the court to gauge whether or not a document, and really quite honestly goes to more authentication. The present sense impression, Judge, that's taught in first-year law school. And that's an impression that someone gets upon observing a startling event. And quite honestly, Judge, there's been 14 days for Ms. Shiftlet to do this. To suggest that after 14 days we've had a startling event that warrants her to come forward with something is ludicrous. So quite honestly, I can't even by the minimum stretch of my mind imagine any situation where present sense impression would even remotely apply to this. They are grasping. And now I know why they're grasping, because it took a significant amount of time for them to come up with a response while we patiently waited for them to address the hearsay issue. This is hearsay. It doesn't come in. And Judge, again, I guess yesterday I was temperate and I was upset, and I'm still that way. And I want to apologize to the court for that, because I don't mean to be, but this is a very disturbing situation, and to suggest that it's present sense impression is just completely ridiculous. And again, I apologize to the court for my temperament.
All right. I've considered the objection filed. There's an affidavit of Mindy Gee. There's also a supplemental affidavit of Mindy Gee. There's been an objection made that portions of those affidavits contain hearsay. I've reviewed it. These statements of Mindy Gee about what she did in terms of taking a phone call are not hearsay. That's her own testimony in the affidavit that's sworn. However, these statements as to what Summer Shiftlet told Mindy Gee, that Mindy Gee is now telling the court, is clearly hearsay. And so the court will not consider and will strike those portions of both affidavits that pertain to any statements made by anything that Summer Shiftlet did say. So that'll be my ruling on those affidavits. All right, with that in mind then, Mr. Evans, would you continue with argument in support of your motion to allow the testimony of Summer Shiftlet?
Your Honor, yes, we've found no rule for the court to disallow further evidence in a hearing. This is not a trial. This is just a hearing. There's nothing that says the court has to follow timeframes, especially if the result is a manifest injustice. We believe that the record that the court's trying to rely on is going to be entirely empty of the facts that go to the heart of the issue. And the heart of the issue for the court is, did Mr. Wood's communication with Ms. Shiftlet, were those influence, and that led to her changing her testimony to law enforcement. So we believe that her testimony is absolutely crucial She is the person that we're talking with in all of these matters, and she wants to testify, and we ask the court to allow her to do so.
All right, thank you, Mr. Evans. Response to the motion, if there's an objection, Mr. Means.
Thank you, Your Honor. Again, I think the argument is well off of what the motion that is before the court. The only, if we could even call it a rule that applies, is they cited Idaho Rule Professional Conduct 4.2 entitled Communication with Persons Represented by Counsel. There is nothing express or implied in that rule that allows the court to entertain this motion. There's no attempt to cite any kind of criminal rule or even an implied civil rule that might be duplicated in the criminal rules here. So we're limited again to the argument of, based on the rule 4.2, communication with persons represented by counsel should justify them in bringing this morning after motion. We've been down this road before, Your Honor, when we had a motion for a judicial protective order in a rule, in Idaho Rules of Professional Conduct, that did not apply. It's the same attempt by counsel here to attempt to do the same thing, which is inapplicable in their request and the remedy in which they're seeking.
All right, thank you, Mr. Means. Your response, if any, Mr. Pryor, please.
Judge, there was a hearing set. I believe Mr. Means disclosed his witnesses and his exhibits. I disclosed my witnesses and my exhibits. Mr. Wood, at the time, through his counsel, chose yesterday at a trial not to present any evidence. He made some brief, very brief cross-examination of some of the witnesses, but nothing else. Now, at this point, at the last hour before we were to make closing argument, this is an attempt to get information in through the back door. And that backdoor process is going to be violative of my client's right to a fair opportunity to present his argument here. Because, Judge, if you allow Summer Shiftlet in, I am going to be compelled to ask the court to continue ruling on this motion so that I can bring Mr. Smith back, put him back under oath, and offer rebuttal testimony for Mr. Smith to counter whatever Ms. Shiftlet says or to concur with whatever Ms. Shiftlet says. And I don't know what Ms. Shiftlet says. I haven't heard from Mr. Smith whether Ms. Shiftlet even has legal counsel. And if she has legal counsel, Judge, Mr. Smith needs to be present for that examination. And quite honestly, if they're going to be allowed to reopen something that this court closed, and they have cited no rule that allows them to reopen this, other than a professional conduct rule, which is totally inapplicable, they shouldn't be allowed to do this. Because if that's where they're going, rebuttal is going to include Mr. Smith again. It's going to include an examination by Dr. Davidson again. It's going to include an examination by Dr. Newton, and potentially one other witness that I'm going to call to address that. And quite honestly, this is just an opportunity to somehow backdoor some information in that doesn't go to the root of what the problem is. I think counsel for Mr. Wood misunderstands. The due process argument is only a very small portion of this argument. The reality of the argument is this, Judge. Mr. Wood engaged in conduct that defense counsels both found objectionable. It's not the impact on the witness that the conduct, that's the question here. The question is whether his conduct itself was egregious enough to have him removed as the prosecutor. It has nothing to do on the influence other than the small portion of due process that'll be addressed later in another motion. The question here is whether Mr. Wood's conduct was egregious enough that it warrants some sort of action by this court. And the example is, Judge, this. Obviously, all of counsel agree that case law on this is very limited and there's not a lot of precedent. But if a prosecutor were to talk to a witness outside of the courtroom and say, oh, by the way, before that witness took the stand, by the way, the defense attorney is a liar and all of these other things that have been alleged well, not alleged, they're on the tape. And then that witness was permitted to take the stand. It would not be the impact on the witness that the court would be evaluating. It would be, what did you say to that witness that potentially influenced you? So that's what the consideration here, Judge, is not what the impact was on Ms. Shiftlet. It's what conduct was engaged in that caused the problem that he should not have gone down that road in terms of the way Mr. Wood presented himself and acted for 20 minutes on a tape. So quite honestly, Ms. Shiftlet's testimony is really irrelevant to this. It's the conduct of Mr. Wood that's in question here. And I vehemently am opposed to allowing Ms. Shiftlet to testify at this point.
All right, thank you for the response, Mr. Pryor. Mr. Evans, rebuttal argument.
Your Honor, just one clarification. If you look on paragraph 10, let me just be clear what the state's wanting to do. So moves this court to allow contact with Ms. Shiftlet. The court knows bar counsel was called with this. So the prosecutor's office contact with Ms. Shiftlet and or allow her to testify in the court. So rule 4.2, if you look at the very bottom, that is the state asking to contact her. And so how do we do that when they have been represented by an attorney? You need to get permission from the lawyer, if she still has one, or authorized to do so by the court. So that was done with bar counsel, and that's what the motion is. So it's the state to communicate with her as well as her to communicate with the court. Thank you.
All right, thank you, Mr. Evans.
Your Honor, may I respond to that rebuttal? Because there were some new arguments made there.
Keep it brief, Mr. Means.
I will, Your Honor. When we go through the affidavits of Mindy Gee, given the rulings of this court, the only thing that's admitted that's not stricken as hearsay are paragraphs 1, 2, and 3 of both of the affidavits. Paragraph 4 on the original affidavit would be limited to, on January 7th, 2021 at approximately 2:53, I took a phone call from a female individual. And then the portion after that would be hearsay. Then it says, I stated that he was not available and asked if I could take a message. The rest would be hearsay. Concluding on paragraph 4, the only portion that's not hearsay then says, and I told her I would relay the message. The phone call then ended. The same thing applies to the supplemental affidavit. 1, 2, and 3 should be admitted pursuant to this court ruling. And paragraph 4 is limited to, on January 8, 2021 at approximately 9:30, I answered a phone call from a female individual who, and then the rest is stricken as hearsay. So we don't have affidavits supporting this motion as a result of the court's ruling. There's also additional hearsay from alleged statements of Ms. Shiftlet in their motion. In addition, if we look at Rule 4.2, and again, this is just brought up this morning, if you look at comment or paragraph number 6, what they're requesting is beyond what the rule cites. Again, there's no grounds to allow this cited in this rule. If they're asking for permission to speak with Summer Shiftlet, I don't think any of us have an objection. The problem is they're attempting to extend the rule or imply what's not in there of give us permission to speak with her and have her testify. That's not part of the rule, Your Honor.
All right, thank you, Mr. Means. Well, counsel, I've considered this motion in terms of where we are procedurally. Of course, we had a very lengthy hearing 2 days ago on the 6th. We took evidence and testimony during that hearing. We then concluded with the hearing and closed the submission of evidence. This is essentially a request to reopen the submission of evidence, and the request specifically to allow, as the motion reads, for the court to contact and hear the testimony of Summer Shiftlet, and then in paragraph 10 to allow her to testify before this court. And that would be based on, again, Ms. Shiftlet's request. It says, as Mr. Means pointed out, with the striking of the portions of the affidavits of Mindy Gee that contain hearsay, then the grounds for the motion don't qualify without those statements. And in addition, the motion is brought pursuant to the Idaho Rule of Professional Conduct 4.2, and the court's not aware of the Idaho Rules of Professional Conduct being a proper basis for bringing a motion. At this time, for purposes of the hearing today and our closing arguments, I am going to deny the motion to allow the testimony of Summer Shiftlet. So the evidence submission is still closed, although we do have the arguments that have been submitted, which will be considered. So that'll be the court's ruling on the motion. This time then we'll proceed with our closing arguments. Counsel, as I mentioned, we went through and reserved today for these closings. I'd like to take those up at this time now And I'll just let you know, I'm intending to hear your oral arguments. I'm going to take a recess at some point and further review your submitted briefing in addition. But Mr. Pryor, it'd be my intention to have you begin with your closing, then have Mr. Means, and then I'll have the state respond in their closing as well, and then see if there's any rebuttal arguments. So, Mr. Pryor, are you ready to proceed with your closing argument?
I am, Your Honor, if I may.
Go ahead.
Judge, I think there's a misunderstanding by counsel for Mr. Wood. The basis for disqualifying a prosecutor is conduct. It's not the impact that it has on the witness, but rather its conduct. And what I spoke about, Judge, was this in the example I gave just a short time ago. The example is this, is that if you have a witness who's about to take the stand in a jury trial, and either party for that witness approaches them and makes disparaging remarks about defense counsel, makes disparaging remarks about the defendant, and I can't see in any situation where suggesting that someone's a wimpy person or looked like he was about to pee his pants are not disparaging remarks. I can't see where calling Mr. Means incompetent is not a disparaging remark to a material witness. And whether Ms. Shiftlet testifies or not for the prosecution is irrelevant. Because if I choose to call her, she becomes relevant. If Mr. Means chooses to call her, she becomes relevant and material. And she's the sister of one of the defendants in this case, who was told, oh, by the way, you know, she won't talk to us, but this is what I'm going to do, and I'm going to charge her with murder. And it would sure be nice when she has competent counsel. Maybe we can get this thing closed up. I can't think of any more direct way that he's trying to circumvent Mr. Means' authority as counsel for Ms. Vallow. It's egregious. It is incredibly egregious. Now, Judge, the Idaho Rules of Professional Conduct have adopted the ABA model rules. And the ABA model rules, and Judge, that says it right in the preamble to the Idaho Rules of Professional Conduct. We have adopted the ABA rules from 1969. And under the ABA rules, ethical considerations, Rule 9.4, because the very essence of our legal system is to provide procedures by which matters can be presented in an impartial manner so that they may be decided solely upon the merits. Any statement or suggestion by a lawyer that he can or attempt to circumvent those procedures is detrimental to the legal system and tends to undermine the public confidence. Now that's from the ABA rules, Judge, which have been, for all practical purposes, adopted in our Idaho Rules of Professional Conduct.
Mr. Pryor, I do want to make a correction there, because the Idaho Rules of Professional Conduct are, as it states in the preamble, largely based on the ABA model rules with some Idaho variations.
That is correct.
I would ask that if I'm following along here, if you're citing to any specific rule of professional conduct, please cite to the Idaho rule, because they are largely the same, but if there's a difference, we need to rely on the Idaho precedent. So, and
I understand that, Judge, and what I'm trying to do is I'm trying to say, in the spirit of adopting the Idaho Rules of Professional Conduct, they considered the ABA rules, and it still goes to the same essence, Judge, which is this. Our Idaho Rules of Professional Conduct require that we do everything we can as lawyers to engage in an impartial system that does not allow undue influence from any party or their attorneys to jeopardize the opportunity for a defendant to have a fair and impartial trial. I cannot think of any situation that is more egregious than a prosecuting attorney who would go in and interview a witness and for 20 minutes not interview the witness, but rather offer a monologue of what his theory is in the case, disparage counsel, disparage the defendant, and manipulate. Now, I want to point out that the prosecutor in this case presented no evidence in rebuttal to counter Dr. Davidson, to counter Dr. Newton, and to counter attorney Garrett Smith. They offered nothing. And to suggest this high scrutiny by Mr. Wood's attorney is completely inaccurate. The question is whether or not an attorney and a prosecutor who's required to live by a higher set of rules has engaged in conduct that jeopardizes Mr. Daybell and Ms. Vallow's right to a fair trial. Now, the purpose of Dr. Davidson, Judge, is this. I did not want to, and I can't speak for Mr. Means, but I didn't want to subject Summer Shiftlet to all of these people out there watching this and put her on the spot. Dr. Davidson got on there and he testified that it's, without credulity, that there was not influence here. He's suggesting, listen, there's no way there wasn't influence here. And he specifically put a report that has been admitted and detailed every single line of where Mr. Means engaged in completely inappropriate conduct. Now, I read the brief from opposing counsel and they said, well, this isn't what was going on, but Mr. Wood's affidavit in the original objection to this, Mr. Wood specifically said in his statement, I did not coach, influence, or intimidate any of these witnesses. Well, I beg to differ, Judge. Dr. Davidson, in no uncertain terms, stated implicitly that these statements clearly were influential in a attempt to influence Ms. Shiftlet, without a doubt. Dr. Newton, when we talked about the process here and what was transpired, what did he say at the conclusion of the hearing? Well, the reason we don't have these sort of things is because it's unusual for these matters to occur other than in front of a jury. But when they occur in front of a witness, it's a rare situation. And you want to believe a prosecuting attorney. You want to believe someone who is supposed to be righteous and uphold justice and do it the proper way. And the tendency with courts is to say, listen, unless you have some proof that the prosecutor has engaged in some conduct that is detrimental to the administration of justice, I think it's appropriate because his job generally is to uphold justice. But what did Dr. Newton, the expert on case law, the expert on authority, what did he say that was compelling? He said, he, meaning Mr. Wood, got caught. Now, getting caught is not the term you use unless either you're fishing or you're lying or you're cheating. And Mr. Woods is cheating, Mr. Wood is lying, and Mr. Wood is doing nothing but trying to influence, coach, intimidate a witness before that witness has had a chance to get in front of a trial. My concern is this, Judge. I don't have any other recordings other than Zulema Pastenes. And I'll be going through that, and we may be revisiting some issues once I've had a chance to go through that in the final interview with Ms. Pastenes. But I don't have any other tape recordings. But what I do have is an interesting thing that occurred. And I know this court wasn't part and parcel of the preliminary hearing back in August of this year. But I had an opportunity during that preliminary hearing to talk with Ms. Gibbs while she was on the stand. And I was questioning her about what she knew, what the prosecutor had said to her. And after I asked her what the prosecutor had said to her, Judge, she immediately turned on the camera and looked directly in Mr. Means's eyes. And I said right after that, why were you looking at Mr. Means?
Your Honor, I'm going to object for hearsay.
This is argument, Judge. This is argument. This isn't the presentation of evidence. I understand, but you're still referencing a specific comment someone made out of in a separate proceeding. I think that's hearsay.
Okay. Well, Judge, my concern is this, is that having to bring up the subject of whether Ms. Gibbs was looking at Mr. Wood when I said that, and the fact that I brought it up, and the fact is, Judge, I observed Ms. Gibbs look in the eyes of Mr. Wood when I'm questioning about what sort of conversations they had. That causes me great concern. And everybody in the world can look at it on YouTube and see that there was concern. So what assurance is the court going to be able to give me that these meet and greets that Mr. Wood has engaged in, these 20-minute monologues, have not occurred with every other witness in this case? Because if the court cannot give me assurance, you're going to require me to go to every witness with an investigator interview them, and question them in detail about what Mr. Wood has talked to them about and whether this meet and greet tactic that is completely unprofessional, that is completely unethical, that is completely wrong, was conducted on other witnesses in this case. And if that can't be questioned to a certainty and assured that there hasn't been influence with other witnesses, how am I going to be sure that there's going to be a fair trial for Mr. Daybell? Because you can't. And there is only one thing this court can do. We need to remove Mr. Wood, and then there'll be additional requests regarding the witnesses further down the line in terms to how we try to cure this atrocity. Judge, there are a number of problems that I have in terms of the Idaho Rules of Professional Conduct. And in terms of the Idaho Rules of Professional Conduct, Judge, we do have Rule 4.2. And Judge, it is misconduct if you violate any of the Idaho Rules of Professional Conduct. And at this point, under 4.2, you are not allowed to encourage or in any way try to contact someone who has legal counsel. I cannot see how Mr. Wood's statements leading Summer Shiftlet through this process of, oh, it's going to be murder charges, and it would sure be nice if we could communicate with Miss Vallow about this. And as Dr. Davidson implied, it seemed to be, and Dr. Newton implied, it seemed to be a back way for Mr. Wood to try to get Ms. Vallow to speak. Now that's clearly a violation if you're trying, even secretly or indirectly, to try to communicate with a witness or with a defendant who has legal counsel. That is a big problem. In addition, he violated the preamble. He is not doing this. There is no way anyone can suggest that his comments did not influence or attempt to influence a witness in a case. That's not justice. 3.8, the prosecutor's obligations. He violated his obligation as a prosecutor to try to present an impartial hearing, and his heightened obligation to do everything that he could to be fair and afford the opportunity for a defendant to have a fair trial is a violation, another violation. And Judge, I can spend hours going through and point out a number of these. Now, obviously, I've been verbose, and I've been verbose in the past, and the court has been very patient with me. But if the court looks at the transcript of the proceedings by Dr. Davidson, if the court reviews Dr. Davidson's report, he makes an emphatic representation that this was influence. Now, Dr. Newton was not going to circumvent the court's authority to make that decision. Dr. Newton was not going to override the court's power and say, oh yeah, this is prosecutorial misconduct. He said that it was up to the court to make that decision. It's up to the court to decide whether this is enough for there to be a disqualification of Mr. Wood. But what he did say, which was interesting to me, Judge, is this. He said, Mr. Wood's behavior was a learning moment, and he meant for his future students at law school. It is a learning moment on what not to do. On what not to do. That would suggest to me that it's a clear ethics violation. What else would suggest to me from Dr. Newton that it was a clear ethics violation is that he would get caught and that he got caught. And again, as I stated before, when someone says you got caught, either you're fishing or you're breaking the law or you're a cheater or you're a liar. I'll pick which adjective because I don't think Mr. Wood was fishing. Now, Garrett Smith in one of his closing arguments at the end, or his testimony, stated, I can't see any possibility other than that it was influencing or attempting to influence Summer Shiftlet, and there is no reason for why Mr. Wood did this. Judge, the totality of the circumstances are this. We have one of the biggest trials in the state of Idaho, and people are watching this with attention that I can't even fathom. We are all under the gun and we are all being watched very carefully. And any first-year attorney who's going through law school is entrusted by ethics and taught about ethics, that these are the things you do not do. And Mr. Wood has been practicing for a while. He has told me before that I did plenty of defense work. I'm a prosecutor now. And Judge, for the record, he also told me on 2 separate occasions.
Your Honor, objection for hearsay.
Sustained.
Judge, I can't think of a reason why Mr. Wood would need to go out and interview Summer Shiftlet. Mr. Wood took it upon himself to go out to Arizona to interview a witness. He knew before he was leaving that he was going to engage in this meet and greet and do this. Because if he didn't know that he was doing it, then he doesn't understand the rules of ethics. He can't say, oh, I didn't know what I was doing. He knew darn well what he was doing. And the only problem and the only complaint is this, Judge. He got caught. In the infamous words of Dr. Newton, he got caught. And to suggest by distracting, saying, well, Ms. Shiftlet will say something else. Or, Judge, the impact on the witness. That's not the standard. It's the conduct. The standard is, was your conduct so bad that it had an impact on the trial in this case? I can't think of a more egregious situation other than a prosecuting attorney in one of the most high-profile cases in the state of Idaho, and I could argue, Judge, in the United States. I don't know how many people are watching me right now or watching us right now, but I would imagine it's significant. And this prosecutor, with full knowledge and at the expense of Fremont County, chose to fly out to interview a witness and suggesting that it was going to be a meet and greet, and then spends 20 minutes of a narrative doing everything he can to influence this witness to testify a certain way. And it's not whether the witness was influenced. It's the fact that he did it. And who else did he do it to? What other witnesses in this case did he do? Because we'll never know. We will never know the extent of what this prosecutor has committed in this particular case. And I can't think of any better reason to disqualify him than the fact that we don't know what else he has done. And quite honestly, Judge, anything he says about what he has or has not done, I have very little faith in anything Mr. Wood will say. And at this point, I will defer to a counsel.
All right, thank you, Mr. Pryor. Mr. Means, your final argument.
Thank you, Your Honor, and I obviously concur with Mr. Pryor on his points made. Does the court want me to go ahead and attempt to argue some of the points made by the state's brief that was filed this morning as well in the closing, or do you want to save that for rebuttal, Your Honor?
I'll leave that up to you, Mr. Means. If you want to address the points in their brief, at some point we'll get to that. You can determine if you want to do that in rebuttal. I'll allow rebuttal, or if you'd like to do that now in your closing, you can.
Thank you. I just, in trying to organize my thoughts and present it in a more efficient manner, I'll try to go through it rather quickly. I filed this morning a post-motion hearing brief in support of the motion to disqualify. Overall, the motion doesn't introduce anything that wasn't presented at the trial in this matter, but to assist the court in the finding that Mr. Wood should be disqualified from this action. It's a summary of the pleadings and the filings which have been filed in here with some dates and then some reference and summaries to each of the 3 witnesses that were that had an opportunity to testify before this court. I'll go ahead and I'm going to object to any and all potential arguments by the prosecution in this case that were not expressly brought up at the hearing, either through lack of evidence or lack of questioning or limited to their cross-examination questions. I think anything else would be in violation of the spirit of the law of closing the evidence in this matter. And we can take that up obviously as we go along. In summary, Your Honor, when you look at the recording and you read the transcript, I think the initial impression is red flags are raised, eyebrows are raised. When you listen to it again, I think it becomes quite a bit more disgusting when you hear the tone and the phrases and the speed of the language and the words used. When we look at here in a summary, you have Mr. Wood admitting on this recording that he was in Hawaii at the time that Mrs. Daybell, was arrested. He was in Arizona at the time that these statements from these witnesses were taken. I still have yet to try to figure out why he's present at any of this. As I listen to this recording over and over, I think the biggest question is why? Why are we here? Now we have spent substantial amount of time with the court, tens of thousands of dollars, many hours in the court's time and the attorney's time, in addressing an issue that should have never been an issue to begin with. And in response, the only objection or evidence that the state has put forward is their initial objection and an affidavit of Rob Wood. And then we have very limited cross-examination questions at the actual hearing. When we look at, in addition, when this tape was discovered, I served on December 17th, and this is part of the record that is readily available for everyone, a specific set of discovery requests to the prosecutor's office asking what contact, in summary, what contact this prosecutor's had with all of these witnesses, and I listed some specific witnesses. Discovery responses were due to that specific request by January 2nd. That's the 14-day limitation according to the rule, Idaho Criminal Rule 16. It's expressly set out there.
Your Honor, I'm going to object. I just don't remember any discovery things being brought up in the hearing.
Well,
Your Honor,
there's a separate issue out there, Mr. Means. I think, correct me if I'm wrong, did you file a motion to compel?
I did file because it's now time to file that motion to compel. But why this is, sorry, Your Honor, I don't mean to.
I'm just going to say that's not being heard today. If there's a need for hearing a motion to compel and you still don't have responses and think that needs a hearing,
sure,
we'll get that scheduled and take that up at another time. So go ahead and move on.
Your Honor, and I understand that my intent for arguing this is we were limited in presenting the evidence before the court of potential other violations of inappropriate contact with the witness, and we attempted through the proper means of discovery to get this evidence from the prosecution, and they failed to respond. There's no request for an extension of time. There's no denial. There was no objection to the discovery. They failed to respond.
Your Honor, I'm just going to object to that again for the same reason.
All right, I'll sustain that objection. We're not doing the motion to compel right now.
Sure. Thank you, Your Honor. When we do a summary of why Mr. Wood should be disqualified here, we have four main exhibits for the court to consider. First one is the transcript of the recording, the actual recording of the monologue, and then the expert reports 3 and 4 of Dr. Davison and Dr. Newton. There were 3 witnesses that testified. Prosecution had ample opportunity to call contrary witnesses or cross-examination, extended cross-examination, and they chose not to. We had attorney Garrett Smith of 27 years. We had Dr. James Davison and Dr. Newton. All of these witnesses, or excuse me, let me go through Mr. Garrett or Mr. Smith first. He testified right up front that he had an opportunity to listen to the recording. In fact, I believe the recording was played at the hearing with him on the Zoom stand, I think we would say, and he testified that it was an accurate copy, an accurate depiction of the conversation between Mr. Wood and Ms. Shiftlet, that it was unaltered and it was a true copy. He then goes on and states that the affidavit filed by Mr. Wood in this case is false according to his opinion and recollection of events, specifically affidavit paragraphs 4, 6, and 7. He also has the opinion that the only intent of, the opinion that the only reason to really engage in this type of behavior was to unnecessarily and unduly influence Mrs. Shiftlet. That Mr. Wood, and I think this adds to the fact that Mr. Wood knew Shiftlet was a member of the Church of Jesus Christ of Latter-day Saints, or LDS, and that he knew she has strong convictions and feelings regarding that religion. He also knew that she has a strong emotional connection with her sister, Lori.
Your Honor, we object. These are facts, not in evidence. We have no idea what Mr. Wood knew or didn't know.
Your Honor, the objection should have come, if that was going to be, at the hearing. This is summarizing his testimony for the court that was not objected at the time that this was presented.
And I'll overrule the objection because it is some summation of this testimony. So you may proceed, Mr. Means.
Thank you, Your Honor. No, it's important to context this entire conversation that Mr. Wood is having with Ms. Shiftlet, having this knowledge here. I think it's an important factor for the court to consider when it's analyzing coercion and manipulation and intimidation and these type of things that come up at a later time. In Mr. Smith's words, he said his 27 years of practice, he's never seen a prosecutor engaged in this type of behavior, that it appeared to be targeted at coaching and influencing the witness, and it appeared to come across as a win at all cost type behavior. This is obviously an issue for the court to consider. Dr. Davison again testifies in reviewing the recording, the transcript, and looking at the affidavit of Mr. Wood, that the affidavit again filed by Mr. Wood, paragraph 4 and paragraph 7 are false according to his expert opinion. He also testified that Mrs. Shiftlet is a vulnerable witness, and the knowledge that Garrett Smith provided to the court of Mr. Wood is important in determining that, yes, there should have been gloves on the hand when handling Ms. Shiftlet in this situation. He goes on to say, Dr. Davison, that the monologue is troubling, that appears to be no apparent effect to seek impartial testimony from the witness, numerous efforts to influence and exploit and shape the witness narrative. He also goes on to say that the prosecution pours his theory of the case into this witness prior to the testimony of the witness, that there are derogatory remarks regarding defendant Chad Daybell and myself. And when you actually look at the recording, he's also in certain ways derogatory toward Mr. Pryor and my client when you look at his opinions that are being expressed. He also attempts to bring in LDS doctrine as an authoritative speaker on behalf of that doctrine. He also attempts to assimilate or build a commonality with Mrs. Shiftlet based on mutual beliefs in the LDS Church, which obviously is completely inappropriate. He also goes on to say that Mr. Wood engaged in coaching, testifying, and had an effort to unduly influence the witness. He attempted to shut down the witness. He attempted to control the narrative, and there's little interest in what the witness's information that will be provided. He's attempting to increase his credibility through derogatory comments and mutual association with religious beliefs. He attempts to, there's a prima facie influence of the witness. He halted any disagreement by Ms. Shiftlet. And again, summary, he engaged in derogatory remarks as if we are in third grade in an attempt to, according to Dr. Davison, affect this witness. He summarizes by saying that there are minimal attempts from the state here to actually get the witness statement rather than to say his own. Now, when we look at the prosecution had an opportunity to present cross-examination and additional witnesses, there was minimal at best. I think they went into some questioning regarding page 5 of the transcript, lines 8 through 11, I believe, and that was the only substantive questioning there. And Dr. Davison handled that with his, my opinion remains the same. The words are there. His report remains uncontested. Dr. Newton, professor, University of Law, published author, also came in and said, and I admire his opinion for not trying to come across as to tell the court what to do, but to give you the information and allow the court to make the decision. He says he was, even though retained by my office, that his testimony was given freely, voluntarily, and without any coercion by any party. His summary, and I think this is important, he identifies and properly identifies Mr. Wood as acting in a quasi-judicial figure, a higher standard of law. Not only do we have the Idaho rules of professional conduct that apply to all of us, but there's a higher standard of law for Mr. Wood. If I could put it in summary, the ledge for a typical attorney to fall off is a little further away than it is for the prosecutor. He goes on to say that Mr. Wood presents his case to the witness as if conclusive and sound. He goes on to provide information that is not readily known. He said, Mr. Wood is providing unknown information to the witness could be found to have unfairly and improperly influenced the witness to alter her testimony. Now, again, this is all caged or described in an attempt to allow the court to come to the conclusion. He also goes on to incentivize, according to Dr. Newton, the testimony of Summer to coincide with the state. This is, as Dr. Newton cites, potentially unethical. It's also potentially criminal. He goes on to say that the prosecution, without question, poured his versions of facts into this witnesses. He calls this horse shedding, wood shedding, and coaching. And he also goes on the site and says, this is widely condemned. This is not getting to the line. This is a no-no. He then had, by Dr. Newton, put Shiftlet in a compromised position. And just thinking of how this is going to affect ultimately this case is mind-boggling at this point in time. He says his behavior bordered on intimidation, that he attempted to possibly circumvent the attorney-client privilege between myself and my client. He goes on to say that the use of religious beliefs, affiliation, and authority is an improper use. The derogatory remarks are improper, and that these remarks and his monologue serve the purpose of predisposing a witness against the defense. This not only he said this violated the spirit, if not the letter of the law of the Idaho Rules of Professional Conduct and potentially the Idaho laws regarding witness tampering. He also goes on to say that there are coercive aspects. This is all of the things which are uncontroverted, unchallenged by the prosecution. I think the question before the court is, what standard do I review this? And it's my argument that this is a standard of abuse of discretion, that the court has to look at this issue and determine, have there been enough violations here just in those cited by those experts to justify removal to ensure the integrity of this process? The Idaho rules, as the court has mentioned, asks us to cite specific rules. I've read these rules. I've read the comments. I see a plethora of issues here. We got a violation of the preamble. We got a violation of Rule 3.4 A, B, C, F. We got a violation of 3.5 A and D, Rule 3.7, Rule 3.8 A, D, F, G, 1, Rule 4.1, 4.2, 4.4, A1, Rule 8.2A, 8.4, A through E. These are major issues, Your Honor. And again, the question has to ask, why are we even here to begin with? These, in addition, this recording is going to have application to this entire process. Your Honor, and looking at their brief quickly, I have in my notes here at the beginning, it's a 13-page red herring. They assert contradictory positions. They imply that the prosecutor may have acted in a matter of error, but that's not enough to disqualify him. It cites various standards of law that they say apply to when it's at trial. But by the way, Judge, we're not at trial, but they attempt to apply that standard. They attempt to apply a standard of review on whether a conviction should be overturned. They cite things such as appearance of impropriety. I think that's a foregone conclusion that we have here. And then goes on to say, no, it's a standard of, well, is the person damaged? Is the testimony damaged? Is there harassment here? Is it an effect of the trial with unfairness? Again, citing cases that are relevant to a trial and saying that shouldn't apply, but by the way, it should apply, we should hold them to the standard, I don't think is a logical conclusion to come through. They selectively cite the preamble of Idaho Rules of Professional Conduct and leave out the portion paragraph 6 of lawyers should further the public's understanding of and confidence of the rule of law and justice system because legal institutions in a constitutional democracy depend on the popular participation and support to maintain their authority. We have some other sites in the preamble which he also violates by derogatory comments of opposing counsel. I think if you go through, there's legal conclusions in their briefing that are not supported by the facts. They make statements such as there was no evidence presented of coercion or intimidation or these type of things. In fact, the one that really caught my eye just off of a few moments of reviewing this is they maintain that Mr. Wood did not tell this witness what to say. And one of the issues brought up with Dr. Davison on page 5 of the transcript, line 10, Mr. Wood says, so what I want. There's just no way around that. There's just no way around that. He's telling this witness what he wants to hear. He's pouring his theory into this case of this witness. This is not a dead issue. There are other witnesses that have to be investigated now as a result of this. And so, Your Honor, I think it's well within the court's discretion, well within the court's authority in this case to disqualify Mr. Wood to protect the integrity of the process. I think when we look over the past 6 to 8 months and we take an opportunity to read the tea leaves, the riots and the objection and the protesting, demanding changes in the criminal justice system is the exact reason why we're here today. This is completely unnecessary. He had no reason to be in Hawaii as if he had to help the Maui police or prosecutor office serve warrants and arrest this person. He's made himself a witness by testifying what he personally reviewed and saw and the statements made. We also have no reason for him to be in Arizona. He had investigators down there from local authorities, from the FBI there to question this person. In fact, it's evidence that he didn't need to be there when he walks out of the room, and by his own affidavit, the investigative process, the questioning of the witnesses was done by the investigators. By him leaving the room, he is showing that he had no business to be there. And then that goes to the idea that I think the court can conclude through a preponderance of this evidence presented that his intent to be there was to manipulate the testimony of this witness. And that goes to violations of the rules, violation of the criminal rules. And this court at the end of the day has to determine what kind of precedent it wants to set with this type of actions. If this type of behavior, in my opinion, goes unwarranted, unchecked, unsanctioned, you are telling myself, Mr. Pryor, the prosecutor, and anybody else who wants to cite this case in the future that you can engage in these tactics without repercussions. That is a dangerous precedent that I don't think any court or any witness or defendant would want to have. I would not feel comfortable engaging in this type of behavior. Justice should prevail. The only person here of these parties as a prosecutor, as a quasi-judicial officer, has a duty to ensure justice, and that was perverted at the least, Your Honor. Thank you.
All right, thank you for the closing. Mr. Means. Mr. Evans, would you like to present your closing now on behalf of this?
I would, Your Honor. Thank you. Your Honor, I'll note initially, counsel said our briefing is 13 pages of red herring. I noticed from counsel's briefing that there's not a single case offered in support of anything. There's no theory, there's no standard, there's nothing. They cite the Idaho professional rules of evidence that I'll get to in a minute, and they cite the Idaho criminal rules. Not a single case. The state's briefing, on the other hand, goes through an analysis of Supreme Court case, letter of law that the court has to follow. So with that, Your Honor, I want to start with the issues that are set out in their motion to disqualify. I think this is important. So there's 6. The first one, violation of the defendant's right to a fair trial. The second one, prosecutor violated the rules of professional conduct and the ABA rules. Number 3, witness tampering and intimidation. Number 4, the prosecutor is now a witness. Number 5, could be a future civil action. And number 6, there's Brady and Rule 16 problems. So I want to be clear, the grounds for the motion to disqualify are 6 things. And I want to lop off the low-hanging fruit. And I want to start first with number 2. So the prosecutor violated rules of professional conduct. The ABA. Your Honor will find on page 5 of our brief, Idaho law from our Idaho Supreme Court. In fact, Justice Moeller, a great Rexburg native, is the one that penned the decision in Kozman versus Dinius. That case very clearly states issues of sanctions of ethical conducts or violations of lawyers in this state is a decision for the Idaho State Bar, not the trial court. This is an Idaho Supreme Court case. The Idaho Supreme Court went on to say that we have designed a comprehensive scheme for submitting complaints and ethical violations, imposing sanctions where warranted, and for appealing those adverse decisions to the Idaho Supreme Court if needs be. Thus, I quote, the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar, close quote. Your Honor, we have a United States Supreme Court case that states in Strickland versus Washington regarding the ADA that those are just guides. They're only guidelines. They're not enforceable. Counsel has never shown one proof that we're under some obligation to follow the ADA guidelines. We can follow them if we want. There's no penalty if we do not. And so issue number 2, Your Honor, the prosecutor violated rules of professional conduct, which they've spent a lot of time on, is completely irrelevant. It's completely irrelevant, as well as the ABA rules. It couldn't be more clear, and I would challenge counsel to show me a Supreme Court case that says otherwise, because I've got 2. Your Honor, so that's issue number 2. Issue number 4, the prosecutor is now could be a witness in the case. I discussed this on page 7 of my brief. Again, I outlined the standard for the court. It's a compelling need standard. The defense must show evidence that it's vital to a case, and you can't get this information anywhere else. So what do we have here? We have got a couple of exhibits with an audio recording, with a transcript, already a part of this court's evidence. And so why do we need Mr. Wood to testify to anything? Why do we need to have him called to do anything that we've got a recording of and we've got a transcript of? Again, it's a compelling need standard. I outline, again, Idaho court cases that counsel does not. I outline these for the court that shows that he cannot be called as a witness. They have shown no compelling need. Again, it's their burden. They've got their 6 issues. They fail on the first 2 that I'm talking about. So that's issue number 2 and issue number 4, Your Honor. I'd like to turn to issue number 5. Mr. Wood needs to be disqualified because there could be a future civil action filed against counties. They provide no authority. They provide no evidence 2 days ago of what that is. They just claim that they need to be disqualified because of some future threat of a lawsuit. They're throwing things at the wall, praying that something sticks. The rule on that I cite in my brief, and we also have a ripeness doctrine problem with their methodology. It's not before the court. We can't disqualify somebody now based on whether or not a case is going to be filed in the future. I know that's black letter law. So again, their issue number 5 completely fails. Issue number 6, Brady and Rule 16. I'm not involved with this on the previous matters, as the court knows. It sounds like Mr. Mean was trying to bring up some issues of whether or not discovery. I don't know what that is. But as far as this hearing, as far as what's gone on and Mr. Wood's conduct to be disqualified, I haven't heard a single thing that would disqualify him because of Brady or Rule 16. You'll note I cite the law in the state of Idaho. I cite the cases that back that up. Everyone has a transcript and a tape of this matter. This is not an issue in this case. So, Your Honor, just a summary of those 6 issues, issue number 2, 4, 5, and 6, there is 0 issue at all with those being dismissed. They haven't met their burden, and it's their burden to meet, and they just haven't met any part of that. So what we're left with is the fair trial and then the witness tampering. No for the court, and by the defense's own witness, Professor Newton. Prosecutors are supposed to talk with witnesses. Dr. Newton agrees with this. This happens all the time. Witnesses are different than jurors.
Your Honor, I have to object to the characterization that this happens all the time. I think he's implying that the manipulation of coercion happens all the time. I don't want to interrupt counsel, but that's a gross misrepresentation.
I'll overrule that objection. Go ahead, Mr.
Thank you. Thank you, Your Honor. Counsel doesn't like the words Mr. Wood used, or maybe the words that are placed in order that Mr. Wood used, but there's no coaching and there's no intimidation. I guess in my mind, I liken this to, and we don't know, with Summer Shiftlet not being able to testify, we don't know what she knows or doesn't know. But I summarize this in an example for the court. So let's take a red light example. So if I'm a criminal prosecutor, and there's a hit and run, and it's an issue of whether the light was red or green. And I have a host of witnesses that say that light is red. And then I have one witness that says, no, I think that light was green. So I bring that witness in and I say, all right, witness, everything that I show on it, law enforcement, all the other witnesses say the light was red, and you're saying that it was green. Here's the other statements you ought to read. You can talk with the other witnesses about this.
Your Honor, if I may, I want to object to this proposed hypothetical. It wasn't included in the hearing. It's not included in his argument today. He's going outside of what he's presented to the court.
This is just argument, so I will overrule the objection. And
Your Honor, thank you. So back to my example, clearly prosecutors can't do this. We can't take a witness and say, everybody else has testified the light was red except for you. Here's some examples. Here's the police reports. Here's all this information. Mr. Wood did not do this. Mr. Wood at no time suggested to a witness what to say. That's just not what he did. Again, page 6 of the brief, Your Honor, we cite case law, Supreme Court. So let's assume this court says, well, maybe it's close to the line. So what's the remedy? The remedy is cross-examination. It's interesting, the defense's own witness, Professor Newton, said, well, you don't have to disqualify Mr. Wood from the case. Maybe we should have a taint hearing. And I outlined this in my briefing, and Professor Newton also outlines that in his briefing. But maybe we need to have a taint hearing to see really what Ms. Shiftlet knows and doesn't know, and what the influence on that is. So again, we do not believe that Prosecutor Wood violated those rules. I want to go to the standard, Your Honor. I think this is important. I think we would all agree it's been difficult to figure out a standard in this type of situation. I believe we've come close. And that standard is held in Weaver. I put the analysis in the documents. In fact, I'm starting on page 9. So we call this the Weaver factors, and I cite the case law to it, but the court in Weaver suggests a 4-part test. And I think that's important to look at on whether or not a prosecutor should be disqualified. Now, let me just summarize some of these, Your Honor, for the court. So we already know the burden to establish the grounds for disqualification rests on the defense. The goal of the court is to shape a remedy which assures fairness to the parties and integrity to the judicial process. When a motion comes from an opposing party, those motions have to be viewed with caution. So I appreciate counsel's argument that that's my argument. Counsel's wrong. I'm citing an Idaho Supreme Court case that is actually adopted in the Foster v. Trial case that adopts the Court of Appeals case of factors in Weaver. I outlined that starting on page 3 of the brief. Your Honor, I want to go through those 4 factors. So this is an Idaho Supreme Court case that adopted the Court of Appeals factors on whether or not an attorney needs to be disqualified. You'll note, Your Honor, it was in a civil standard case. It wasn't in a prosecutor's case, but I think the applicability still applies to lawyers. So let me just go through those 4 standards. Standard number 1, whether the motion is being made for the purpose of harassing the defendant. Obviously, the motion is being made by the defendant. Everybody's represented by the counsel. And so nobody is being harassed. No defendant is being harassed by Mr. Wood. The second factor to establish whether a prosecutor should be disqualified is whether the party bringing the motion will be damaged in some way if the motion is not granted. There's been a lot of argument, Your Honor, about the rules of ethics, about the Idaho criminal rules. There's not been one thing that I can remember hearing of how these defendants have been damaged in any way by Mr. Wood or Ms. Shiftlet, frankly.
Mr. Evans, I want to back up a little bit to a comment you made talking about these Weaver factors.
Yes.
Did you indicate that the Weaver factors come from a civil case?
So this is, it is a civil case. In fact, you have that cite, Your Honor.
I think it's in the brief.
Yes, if you look at page 3, so what I've done in the briefing, cited the American Bar Association. Again, it's not authoritative, but the removal specifically of a prosecutor is cited there. I've cited matters as close as I can get as far as disqualifying a prosecutor because of conflict of interest. Then I also have the Weaver factors that I think it's a disqualification of a lawyer, Your Honor.
I understand. The Weaver factors, I guess, getting back to this first factor you just went through pretty quickly, was question whether the motion is being made for the purpose of harassing the defendant.
Right.
And if this comes out of a civil case, then would that not just be better to say the opposing party?
That's correct, Your Honor.
The answer is the motion's being made by the defendant, so of course that wouldn't apply, but if you looked at this in a context of this case, and we're looking at the opposing party, isn't that more accurate to state that it would be to harass the opposing party, not necessarily defendant as defined a criminal defendant, whereas in a civil case, a defendant could just be the other party?
I agree with that, Your Honor.
Okay, thank you.
Your Honor, so the second factor set forth by Weaver, and again, this is as close as I'm going to be able to get the court, and I've spent quite a bit of time over the last couple of days looking at this. But the second factor that I've talked with before was the party bringing the motion will be damaged by some way if the motion is not granted. I think I've reviewed that. I've provided the case law on that portion for the court. A couple of other comments from me regarding that. There's no evidence from Ms. Shiftlet that she was intimidated, threatened, or coerced. There's no evidence of that. She was represented by counsel. Her attorney never objected to anything that Mr. Wood said. And the defendants, again, have shown no damage to their client in any way if Mr. Wood stays on the case. So I'll move to the third factor that establishes disqualifications of lawyers in the state of Idaho. And I want to spend some time with this, Your Honor. So whether there are any alternative solutions or is the proposed solution the least damaging possible under the circumstances. And I want to use the defendant's expert witness of Dr. Newton because the court will recall, I spent quite a bit of time asking him the questions on this. And the question is, okay, what is the remedy? And so Professor Newton discussed some of those. And we already talked a little bit about the pre-trial taint hearing is what he called it. That is set forth in his briefing, page 17 and 18, paragraph 62 and 63. And what I understand that to be is the court could determine, is she going to be called as a witness? And what, if anything, is going to be false or inaccurate testimony in the case? So other potential alternatives is not allowing Ms. Shiftlet to talk in trial or limiting that communication. But in the case, if this court finds any questionable conduct, one of the factors the court has to consider is, okay, what is the solution that's going to be least damaging in the situation? I note, and the court notes, there's not a single one of the defendant's experts, all were asked if they know of a single case in a situation like this where a prosecutor was disqualified by a court. I don't know that. The defense experts had no idea. I mean, there's not a single case that leads that to believe. So I assume that perhaps in those type of situations, courts are finding alternate solutions short of disqualification. So again, the third factor of Weaver, also adopted by the Idaho Supreme Court to establish the disqualification of a lawyer. The last factor, Your Honor, whether the possibility of public suspicion will outweigh any benefits that might accrue to continued representation. Again, Your Honor, the burden is upon the defense. They claim quite a bit of information of, well, we didn't call it as well. It's their burden. It's their burden throughout. The Idaho Supreme Court has said that very directly. So their burden is upon them to show any public suspension or suspicion. None has been offered in this case. Ms. Shiftlet is not Mr. Daybell. She is not Ms. Vallow. She's a potential witness in the case. And there's no evidence to present that Mr. Wood directed her to say anything other than tell the truth. So, Your Honor, based on those, and again, we're trying to provide the court some information of what to go through, but every single one of those 6 factors, the state's briefing identifies the legal standard and the cases and the analysis for the court to consider. We would encourage the court to look at that prior to making its decision. I'm sure we probably found a lot of the same things. Let me just summarize with this, Your Honor. These motions are made by someone other than a former or current client, which heightens the scrutiny, justifiably so. Motion to disqualify in the state of Idaho are disfavored. They must be viewed with caution. The burden is upon the defense. Our argument is the Weaver factors, and again, I outlined some more that are the criminal factors. I outlined the ABA rules. Our assertion is Mr. Wood did not violate those factors. And even if he came close with those factors, this court has the ability to structure a remedy, just like the defense's expert says. You don't need to disqualify Mr. Wood. There's a remedy for this. And the court's fully within its capable powers to be able to do that. All the defendants are represented by attorney. Their rights are all protected in this. And again, the remedy is not to disqualify a prosecutor. We have a trial in 7 months, Your Honor. I cite the Supreme Court cases on the dissipation of things that occur now versus trial. I think that's important for the court to consider, is if there's a taint, even if there is a taint now or a taint on October 1st of 2020, where is that going to be in 7 months? We have court cases, not summations, not guesses. We have court cases. They outline to the court what those are. We cross-examine the witness if they've been coerced, if they've been doing again, courts have said the appropriate remedy for this is to cross-examine, or there's alternatives, exclude the witnesses, those types of things. So, Your Honor, based on this, based on the law in the state of Idaho, based on the law in the Supreme Court of the United States, and what we have presented to you, there is not a way to disqualify the prosecutor, Mr. Wood, from this case. Thank you.
All right, thank you, Mr. Evans. Counsel, I'm going to allow for rebuttal argument. Before I do that, I'd like to take a brief recess to allow mostly for the court reporter to catch her breath here. And so I'll let the rebuttal arguments be made after that. I've got 2:55, so let's come back on in 15 minutes at 3:10, if that works for everyone.
That works for me, Your Honor.
All right, we'll take that 15-minute recess. Thank you.
Thank you.